Good morning. I call to order the meeting of the panel on public service. We have a quorum. It is also the appointed time. Let's start the meeting. Agenda item number 1, information papers issued since the meeting on 18th of December 2023. We have received one information paper since the meeting. The paper number is LC paper number CB brackets 41117/2023 brackets 01. Do members have any questions on this paper? If not, let's move on to the next agenda item. Agenda item number 2, items for discussion at the next meeting. The next regular meeting will be held on 18th of March, Monday at 10:45 in the morning. The 2 items to be discussed are civil service related matters featured in the 2024-25 budget and 2 family-friendly employment measures for government employees. Do members have any comments regarding the items to be discussed? If not, we will ask the administration to prepare the relevant papers. Agenda item number 3, civil service disciplinary mechanism and enhancement measures. Let's invite the representatives of the administration to come inside the conference room. All right. Members who wish to speak, please press the request to speak button. I'll first declare an interest. My family consists of civil servants and retired civil servants. Mr. Lai Tongkwa, I would like to declare that I am a retired civil servant. I would also like to declare that a family member of mine is a retired civil servant. Thank you. Any other declarations? If not, we'll invite Mrs. Ingrid Young, Secretary for Civil Service, to brief members on the paper provided by the administration, LC paper number CB brackets 4215/2024 brackets 03. Thank you, Chair. Today, we have a paper that briefs members on the civil service disciplinary mechanism and the enhanced measures introduced in recent years and their implementation progress. The government attaches great importance to the conduct and integrity of the civil service and takes a zero-tolerance approach towards officers who have breached the law or misconducted themselves. We have adopted the principles of fairness and partiality to have a civil service disciplinary mechanism that would ensure appropriate punishments are meted out to officers who have misconducted themselves. We have first the summary disciplinary action. If an officer is suspected to have committed an act of misconduct, summary disciplinary action may be taken, which would include the issue of a verbal or written warning without the need for a formal disciplinary hearing. And we also have the Secretariat on Civil Service Discipline, SCSD, that would undertake formal disciplinary action. We have to make sure that the civil servant suspected of misconduct is given a fair hearing and sufficient opportunities are given to defend himself or herself. We have the relevant safeguards. If the civil servant concerned is found guilty of misconduct or convicted of criminal offense, the disciplinary authority may impose punishment on the defaulter having regard to the gravity of his or her misconduct or criminal offense, his or her disciplinary and service records, etc. In the 5 financial years from 2018 to 19, 2022 to 23, a total of 1,995 civil servants were punished with summary disciplinary action for misconduct of less serious nature, and 1,124 with formal disciplinary action for serious misconduct or criminal conviction, among which 195 were removed from the service. From 2017 to 18 to 2021 to 22, a yearly average of 31 civil servants were removed from the civil service. In 2022-23, the removal figure was up to 60. In 2023-24, as at 31st of December 2023, 38 officers have been removed from the service. The 2023 policy address sets out that the government will continue to strengthen the civil service management. We have been implementing the following enhancement measures since 2023. A pilot scheme on strengthening department's monitoring of summary disciplinary action against officers on probationary or trial terms. The scheme would ensure that officers on probationary or trial terms, their minor misconduct can be appropriately handled in time by the summary disciplinary action before they are confirmed to the permanent establishment. The scheme has been working smoothly so far. We will review the effectiveness after its implementation after 1 year. The second would be the requirement for all officers to report to their heads of departments if they are arrested no later than 7 calendar days. This would ensure that the department heads can closely monitor the relevant cases and take timely follow-up actions when necessary, including transfer or interdiction. Third, we have strengthened effort on capacity building in investigation work on disciplinary cases. In this year, we will continue to organize workshops and dedicated sessions for departmental managers who are required to deal with disciplinary matters. Fourth, the new arrangement to strengthen monitoring of summary disciplinary action and internal investigation. We have introduced a new monitoring scheme in January of this year that would require bureaus or departments to provide senior departmental management and the SCSD with half-yearly returns on progress updates of their disciplinary cases. This would step up monitoring by senior departmental management of the processing time of disciplinary cases and the appropriateness of the level of punishment imposed in terms of strictness and leniency. We will continue to raise awareness of the senior management on the need to closely monitor the progress of disciplinary cases. And we will review the scheme 1 year after implementation. Thank you. That's it for my report. I'll now read out the order in which members are going to speak. Ms. Nixie Lam, Mr. Chen Chen-ying, Mr. Stephen Ho, Mr. Kwok Wai-kung, and Dr. So Chen-wing. 3 minutes per member. Questions and answers included. I will allow second round, so please be brief in this first round. Thank you, Ms. Nixie Lam. Thank you, Chair. I would like to ask that for officers who are acting in positions before disciplinary hearings are held, would you consider only their performance in the appraisal reports? Are there any other measures in place that would consider their performance in other periods? Also, in the appraisal of the performance of civil servants, such appraisals would often be undertaken only by the direct supervisors. Would you refer to performance appraisals in other sectors so that you would have a more multifaceted appraisal of civil servants and perhaps a more quantified performance assessment? Thank you. Secretary, thank you. For misconducts or criminal behavior. We will consider, no matter whether they're acting or not, the gravity of the misconduct or the criminal behavior concerned or the breach of performance. We will also draw reference to previous cases. We will also allow for representations to be made by the relevant officers. So it really does not matter whether they are acting in that position or not. After such officers are suspected of having misconduct themselves or have done something criminal, the departments concerned may consider transfer or interdiction. So as I said, it does not matter as to whether they are acting or not. If it is confirmed that they have committed criminal behavior or misconducted themselves and they are no longer appropriate to act in their position, the acting arrangement will be cancelled. I want to ask, so will the next step be taken by the direct supervisor, or will it involve the Civil Service Bureau or the heads of the departments? I think it would depend on the gravity of the misconduct or the breach. We also have departmental procedures as to which ranks will deal with the relevant misconducts concerned, depending on the rank of the officer. If the misconduct is serious, it will be referred to the Secretariat on Civil Service Discipline, SCSD, for follow-up on a central level. The Secretariat would investigate and confirm whether the allegations were substantiated. Afterwards, if they are substantiated, the complaints will be referred back to the departments for follow-up. Regarding the work misconduct of civil servants, I believe it's not easy to quantify the performance of civil servants, but I believe departments have stipulated clear requirements for the performance of civil servants, and direct supervisors would be more aware of whether such civil servants have complied with the requirements, and if they could not comply with the requirements, why they could not comply with the requirements. I believe that would be clearly reflected in the performance appraisal undertaken by the direct supervisor. If the performance can be quantified, I believe existing appraisal mechanism would reflect that. Thank you. You can speak for the second round because you've spoken beyond the time limit. Thank you. Mr. Chan Chen-ying. Thank you. When I was working in a public position before, I did observe that many employees or civil servants would take sick leave, and how long would the administration take to process cases where excessive sick leave is taken? I understand that an enhanced civil service mechanism, that is the pilot scheme on strengthening departments' monitoring of summary disciplinary action against officers on probationary or trial terms, was implemented. I want to know how many cases you have dealt with in the past year. Regarding summary disciplinary action, there is also an enhanced measure that half-yearly returns on progress updates on disciplinary cases will be submitted to senior departmental management and the SCSD. I think there was intervention before by senior departmental management, but did the Civil Service Bureau intervene of your own accord when you saw such cases? Thank you.
For the first question, in relation to the summary disciplinary actions that dealt with within the departments. So we haven't collected the data. For unduly long cases, usually they are the subject matters of formal investigation. We have to carry out an investigation, and depending on the complexity of the case, the length varies. But then between completion of investigation and decision to initiate a disciplinary hearing and then completion of the hearing, well, 85% of such cases can be dealt with within 9 months. And then for court cases, upon completion of the court hearings, if the officer has been convicted, then there's no need for us to have another hearing. 96% of them can be dealt with within 3 months. As to the cases of officers on probation or on trial, we are carrying out a pilot scheme in 4 departments. There aren't too many cases. There are a total of 21 such cases. For the majority of them, if they are not near, if the minor default doesn't take place near the end of their probationary period or trial period, usually the cases can be dealt with appropriately in terms of timing. And then finally, under our monitoring system, indeed, if our secretariat receives information submitted by departments, if we notice that some cases have been dragging for too long, we will certainly intervene. We will carry out inquiries with the departments, trying to see if they need our assistance, the nature of the complexity, why it has taken that long. If we're able to give any helpful advice, we'll certainly do so. Secretary, I think you haven't answered the other question from Mr. Chen, that is sickness being the reason dragging the cases, and what is your countermeasure? Well, if the officer has been certified by a medical doctor in Hong Kong that he or she is indeed indisposed, then we have to give him or her a reasonable period of time to recover. But then if we have doubts in relation to the case, say, for example, despite having a medical certificate, if we still have doubt, then we can certainly, first of all, require the officer, as I addressed the panel last time, ask the officer in question be seen by a government doctor. And in serious cases of delay, we can convene a medical board, and the medical board is being convened is composed of government doctors to check if the case is serious and to see whether he or she is still fit for the post as a civil servant. Thank you. Next, Mr. Stephen Ho. Thank you, Chair. Just now, Mr. Chen Ying has asked a question leading to many questions in our mind. We do know that when officers are under investigation, they will prolong the length of the case because they say that they are sick. So we are interested in the relevant procedures. Secondly, for us, we believe that the Civil Service Bureau is in a difficult position. Quite unlike the private sector, you can't fire them easily. And if you put a very high threshold for them, then it will be difficult to recruit officers. Now that you have introduced the enhanced mechanism, probably you need to make fine-tuning. Please do not be afraid of introducing reforms. And thirdly, please elaborate on the actual operation. Mr. Chen referred to certain cases, but I don't quite understand it. When a court convicts an officer, you have said that it will take 3 months' time to complete the case. And why you still have to take 3 months? I think the facts have been established. I'm sure there's room for improvement. Now, there are many government departments, and they are of a different nature, one from the other. Some are there are teachers, social workers, disciplined officers, disciplined services, etc. If you have the same yardstick for all officers, will there be a problem? We may not be too familiar with the actual operation. Well, on the first page of your document, you have the summary disciplinary action. But then sometimes it is a matter of perception. Recently, there is this case of a teacher being caught in an incident. It may not actually be a case of a breach of the law, but then it will be bad in terms of perception. So how would you judge the case? Now, if you try to intervene in such a case, well, actually, they may be able to claim that they have been acting in accordance with the Civil Service Code and there's nothing you can do about it. Secretary, well, if there's room for improvement in relation to our civil service disciplinary mechanism, we'll certainly do so. We do want to enhance the efficiency on the one hand. On the other hand, we hope that the handling or the punishment is in line with the public perception. We want to be appropriate in terms of the severity or the strictness and leniency of the punishment. Mr. Ho would like to know whether we apply the same yardstick or whether it differs from one department to another. Well, as a result of the different grades and posts, just like the case of teachers that Mr. Ho refers to, well, if teachers are having a default of the law or if they misconduct themselves, well, I think we do have different requirements of teachers when compared with other civil servants. The Education Bureau itself has already got, well, in fact, I've been with the Education Bureau. I used to be the permanent secretary of the Education Bureau. Generally speaking, for teachers, we do have certain professional requirements of them. And this applies to teachers within the government. So when teachers misconduct themselves, well, it will be regarded as more serious when compared with other non-teacher civil servants. Say, for example, for the case of careless driving, for a government driver, whether he's on duty or off duty, if he's been convicted by court for careless driving vis-a-vis a civil servant who has been convicted of careless driving, in both cases they have to report to us. But then as a result of the nature of their jobs, it is a different case. So I do agree with Mr. Ho, and this is being reflected there. Broadly speaking, the mechanism, the procedures are the same. But then as a result of the difference in the natures of the jobs, and in fact departments have well in advance made clear to our colleagues that we do have different considerations, then that would be the nature of our consideration. Well, Chair, sometimes we don't just ask for adherence to the requirements on paper, but then for social workers, teachers, or even staff of the Radio Television of Hong Kong, we do have special requirements, but then we may not actually have very objective criteria that can be easily understood by the public. Well, Secretary, please consider Mr. Ho's concern, whether you have more information for him that is prolonging the length of the investigation by claiming sick. And then what about public perception? And what about more measures to attract talents? I think there's one other outstanding issue. That is, if a criminal case is involved, if you say that a criminal conviction will be dealt with within 3 months' time, can you tell us what you mean by 3 months? What I would mean is that there is a court decision, and the court has decided on the punishment, and then 3 months will count. We need to consider carefully the judgment of the court, because in the judgment, the court will set out the facts of the case. Say, for example, the liability of the civil servants and whether the officer should be dealt with leniently. And we have to give the officer a chance to be heard. And so it will take roughly 3 months' time. In between, we will also consider similar cases in the past. But of course, we are not bound by precedent cases, but we do make reference to them. At the end of the day, we will come up with a final decision to dispose of the case. Next, Mr. Kwok Wai Keung, please bear with me. I have a hoarse voice today. Well, when an officer has been convicted by court, or we have a serious misconduct, or there is a repeated we have an officer repeatedly misconducting himself, yes, I know you have a mechanism to deal with them. I'm sure the public welcomes such a mechanism. And if there are black sheep within the civil service, tarnishing the image of the civil service, discrediting the government, we surely have to deal with the matter. I think you do have the support of the public. Of course, I would like to see the procedures being expedited. Chair, I've come across such cases. Say, for example, someone has been suspected of having committed a criminal offense, but then the criminal investigation was suspended and there was no prosecution. Civil servants and civil service unions are concerned. That is, if the criminal investigation has been called off, but then the department will still ask the officer to be on leave and he hasn't been reinstated. And there's indication that despite the termination of the criminal investigation, it is said that departmental investigation will still go on. So my question is, for this internal investigation mechanism, are you worried that this will replace the judiciary or the criminal investigation? Many civil servants are worried. They are afraid that the investigation team may not actually have any investigative powers, even though there may be a disciplinary hearing, but then they are not backed up by the judiciary, and they wonder whether this is indeed in line with the existing civil service code. So, Chair, I would like to put forward this question. Secretary, well, in relation to Mr. Kwok's concern, this is indeed the case. For our disciplinary mechanism, before we consider anybody has been in breach of the law or whether an officer has misconducted himself, is different from whether there will be a prosecution. Because whether there will be a prosecution and whether we will have disciplinary investigation, there are two different sets of criteria. We all know that for us to initiate a criminal prosecution, there is a set of yardsticks. I won't say that the criteria are totally different, but then the threshold would certainly be a bit different. Well, for some colleagues, they might have been suspected by the law enforcement agencies that they might have broken the law and they might have been subject to criminal investigation. In appropriate cases, will interdict the officer or transfer the officer. If no prosecution follows the investigation, departments still have to continue with the investigation. We need to collect all the evidence and come up with a consideration and then a decision to see if the officer has misconducted himself or herself. Of course, it shouldn't take too long, and that's why among the 4 enhanced measures, one being that we have invited the law enforcement agencies to train our officers in relation to investigative skills so that we can be more specific and more efficient. It is indeed necessary to carry out investigation because it doesn't mean that when the case doesn't warrant criminal prosecution and the officer can be totally cleared of misconduct. Say, for example, in the year 2019 when there was the Black Clad riot, some civil servants might have been investigated by the police to see if they did take part. At the end of the day, they were not prosecuted, but then departments would still see the need to have an investigation.
Chair, I understand that there is a need to conduct an investigation on the part of the department because we would want to ensure there is no black sheep in the department. But if there is no criminal prosecution, the department should be prudent and careful to make sure that the officer concerned would have an opportunity to defend themselves. Thank you. Secretary, we do understand we have all along been providing training to bureaus and departments on this, and we have also enhanced our mechanism to expedite the investigations. Thank you. Well, I think for certain civil servants, they may not understand the procedures, so you may have to do more explanation on this in the sense that what should happen before the disciplinary hearings. Also, for some cases, there may be criminal acts involved and the cases are being dealt with by courts or the police force. Is it possible for the administration to conduct investigations in parallel in order to expedite the progress of investigations? Chair, usually we will not conduct departmental investigations in parallel with criminal investigations because we do not want to hinder the criminal investigations in any way. And if the colleague concerned in the end is criminally prosecuted, we will definitely follow up on that thereafter. So we would usually wait until criminal investigations are concluded before we undertake departmental investigations. If in fact they are already criminally prosecuted, we will not need to deal with them by internal investigations because, as I said earlier, the 85% of the cases are dealt with in 9 months. Of such cases are dealt with in 9 months. Thank you. Next, Ms. Dr. So Chang-Wing. Thank you, Chair. I look forward to the review of the pilot scheme after 1 year. I hope that the administration would achieve great results because I believe the pilot scheme would be beneficial to the efficiency and effectiveness of the civil service. I do have some questions. You have chosen 4 departments to implement the pilot scheme. What were your considerations then for selecting the 4 departments? That's my first question. Secondly, from the paper, I could see that in 2017 to 18, there were 21 officers removed from service or dismissed. In 2022-23, it has reached 60 for the total number of removal cases. So that is a twofold increase. In fact, in 2021 and 22, there were quite a number of removal cases as well, 52 to be specific. But the increase obviously is significant. I can see that the Bureau has been stringent in enforcement, and you have removed a number of black sheep from the civil service, but I want to know the reasons behind the significant increase and what kind of misconduct or criminal behavior concerned was involved in these cases. Thank you, Secretary. Thank you, Chair. The pilot scheme would target officers on probationary or trial terms, and the misconduct concerned would be misconduct of a less serious nature. For serious breaches, the cases would be referred to the SCSD. So the pilot scheme would only target cases where misconduct of a less serious nature is involved. The 4 departments were selected because they have a relatively large establishment and they have a number of officers on probationary or trial terms. So we have selected the 4 departments in particular for the review of summary disciplinary actions. We believe with these larger departments, we will have better sense of what is going on. And these departments also have both disciplinary officers as well as civilian grades. They also have different scopes of work, and these factor into our consideration selecting the 4 departments. As for the increase in the number of removal cases, as the member said, it is due to us implementing more stringent procedures with removal of civil servants. And as I said, we have drawn reference to similar cases in the past, but that won't be the only deciding factor. We will look into the cases on a case-by-case basis. For certain cases, as you may remember, during the pandemic, we had required civil servants to undertake or to take the number of required dosages for vaccinations. If the relevant civil servants concerned can submit medical proof that they could not take vaccinations, they could come to work, but there were civil servants that did not do either. We would regard these employees as absent from work without proper reason, and thus we have dismissed them. I believe Dr. So asked about inappropriate conduct concerned. What was the inappropriate conduct in these cases? Thank you. Well, I think most of them would involve conviction of criminal offenses, such as offenses breaching the public order ordinance, conspiracy to defraud, fighting in a public place, and so on. For misconduct, that would include abuse of power, absent without leave, and tarnishing the reputation of the government. I can see that the total number of removal cases has increased, as the member mentioned. Why is that? Well, I think, as I said earlier, we have implemented more stringent standards. And as I said earlier, some cases involved officers who did not comply with the requirements for undertaking vaccinations, and thus they were regarded as absent without leave, and we have dismissed such employees. Thank you. Mr. Leighton Kwok. Thank you, Chair. I would like to ask about paragraph 10 in the paper. It is said that for civil servants, officers on a permanent establishment who have moved to another office on trial terms, or officers who are not confirmed to the permanent establishment. Well, actually, in fact, I want to talk about the second enhancement measure, that is a requirement for all officers to report to their heads of departments. It would concern all officers, including non-civil service, contract staff, post-retirement service contract staff, and other government staff employed on non-civil service terms. They are to report their arrests to their heads of departments no later than 7 calendar days. Why don't they need 7 calendar days? I consider that relatively long, because within the 7 days they could still be acting in their office. So these officers are asked to report to their heads of departments that they're arrested, because the heads should consider as soon as possible whether follow-up actions are necessary, such as transfer or interdiction. So I consider the 7 calendar days to be too long. I want to know what the administration's justifications are for setting the 7 calendar day requirement. I can see in paragraph 12 that workshops and sessions would be held for staff that would deal with disciplinary matters. I understand that the Civil Service Bureau collaborated with the ICAC. Why didn't you ask the Department of Justice to get involved in this? We obviously have to ensure that there is procedural justice. And when we consider that investigation should be taken, we have to make sure the rights of civil servants are protected, and I believe the Department of Justice would play a key role. So why didn't you ask the Department of Justice to get involved instead of the ICAC, which I consider to have no involvement in this? It is also said that a dedicated train-the-trainer session was held. But I think this would be an indirect way of going about this. If departments are to deal with disciplinary matters, they should all come attend this session. Wouldn't that be more direct? Why would you need a train-the-trainer session? Thank you. Secretary. Thank you, Chair. Regarding the report, their arrest requirement, we have implemented the 7 calendar day condition because they may be detained for 48 hours. We wanted to give them some time, for example, during the weekend, if it was close to the weekend, so that they could be given time to deal with other matters. But we wouldn't allow them too long a period. That's why we considered 7 calendar days to be a condition that have struck a balance between different considerations. As for training provided to colleagues, it would concern training on investigation of misconducts or breaches. And especially for prolonged investigations, for supervisors or personnel officers, training is provided to them to help expedite such prolonged cases. For certain officers, they are not used to conducting investigations, so we have also provided training to them to ask specific questions and how to collect evidence. So there is training in general for investigation skills. We believe we have invited several departments to get involved, one of them ICAC, as for legal knowledge. For formal disciplinary cases, before the Secretariat commences investigation and when they commence such investigations, the SCSD colleagues are in fact very familiar with such investigations, so they will clearly explain to the officers being investigated on day one of their rights. And for the Department of Justice, should we require legal advice, we will consult the Department of Justice. And for each case, the Department of Justice would give advice on the case or overall enhancement of the mechanism. So we have got the Department of Justice involved in our process. Thank you. Let me add 2 points here. Whether it is a formal case or a summary case, often when officers feel aggrieved, they may take further actions such as legal action. So for colleagues undertaking disciplinary investigations, they should be clear about the legal requirements and the procedural justice. So I think that is the reason why you should get the Department of Justice involved. If the colleagues concerned do not understand what would entail for procedural justice, mistakes may be made, and it may open a can of worms that would take much time to deal with. So I hope the administration can really take this into consideration to make sure the colleagues handling the investigations are well aware of the requirements, and you can teach them such through training. For example, if there is a prosecuting or investigating officer who is asking questions next to me, that may already constitute a breach of procedural justice. So they should not make even minor mistakes, because that may compromise the investigation. Thank you.
Secretary, we certainly consider this. Well, in fact, we have got training, and in fact, colleagues of the SCSD are professional, and in fact, we do visit departments regularly, in particular departments having more disciplinary cases. We'll try to address the difficulties that they have encountered, or if a department has a case or has cases that were not dealt with appropriately, and we'll try to give them advice. But we are grateful to Mr. Lai for his suggestion to provide more training. If I may also answer another question that is outstanding. For the trainer sessions, why not train the trainees directly? Well, we are making a start, and we hope that by having trained the trainer sessions, it will be more effective. A department may have 7,000, 8,000 or 10,000 officers, and in fact, many controlling officers may have to deal with disciplinary cases. If we are to cover each and every one of them, it will take a long time, and then other departments may not be covered. So we're making a start, and we do intend to deepen our arrangements, and we urge the trainers to share their knowledge with their colleagues, and we hope that one day we can extend the program so that all officers who have to assist in investigations can benefit. Members, if you want to have a second round of questions, please indicate. It's now my turn. I do agree with the view that for civil servants and non-civil service contract staff, we need to have a mechanism so as to enhance the appropriate image of civil service. The 2019 Blacklet riot illustrates that there was oversight in the past, causing embarrassment to the government. Because we really have to convince the public that we are providing good public service to the community. So the government should work harder on this. Now I've got my questions. Just now there was the mention of the need to follow the mechanism, and then if someone has been arrested, a report or a declaration must be made within 7 days. There's no later than 7 days. What about minor offenses like littering or breaching or committing a traffic offense? Is there a need to make a declaration? Is there a need to make a report on the part of the civil servants? And what about public organizations, subvented organizations, like government teachers or teachers in aided schools? What about social workers? Social workers work under subvented organizations. And what about hospital authority doctors? The hospital authority is a subvented organization. So what would happen to such employees? Are we having very similar requirements? I do hope that the variation would not be huge, because the public can't really tell which are government departments and which are not. Like teachers, they would look at teachers in the same breath. So I want to know how you can ensure the public that they understand the operation. So are you going to tell the subvented organizations what government requirements are like? And what about outsourced service, like cleansing service? In the eyes of the public, they can't tell that it is outsourced service. They would regard it as part of the overall government service. So please make sure that you can enhance the quality of the service, in turn enhancing the image of the civil service. In the past, I used to be with the police. I think the police are really well trained in their investigative skills. But for other government departments, investigation is not their job. So if you have to carry out a disciplinary action, then perhaps the departmental officers would need more assistance in terms of interviewing skills and investigation skills. So, Secretary, what are you going to do to make sure that such will be enhanced so that the accused officers will be convinced that they have a fair and just treatment? Well, For fixed penalty tickets, once you have paid it, you are discharged of your criminal liability. So there's no need to report to us. Even if you choose to contest the case, there's no need to report the matter to us. There are also other minor cases, like someone has been summoned to go to court. Then this is a different story. You need to report to your department, and you have to report the conviction or otherwise of the case. And then for subvented organizations, as well as the contractors of our outsourced services, well, in the latter case, it's a matter of the government procuring the service from the contractors. As to how contractors conduct the business, well, they have to deliver service which is up to the standard required of them by the government. So in terms of staff management, if staff management is poor, and in delivering public service, if their own employees misconduct themselves and in turn compromises the quality or the level of service to be provided to the service, then the government will query the contractor, and the contractor will put pressure on their own staff. So that's how it operates. For subvented organizations, well, civil servants are a bit different from staff members of subvented organizations. For civil servants, we are appointed under different mechanism. So our disciplinary mechanism, among other things, are unique and different, and that's why we have to operate in accordance with the Civil Service Administration mechanism. I know that for many subvented organizations, they may not have the same procedures as ours, but then they still honor the spirit that they will carry out an investigation, and then the investigation itself would be fair and just, and they will give the defaulter the chance to be heard. So I think the major elements are roughly the same. The essential elements, like it has to be fair, the investigation has to be thorough, and then in addition to other than criminal elements, what I mean is that even though there's no criminal prosecution, the investigation and the handling of the case has to be effective and efficient. So we have shared our views with the policy bureaus overseeing the subvented organizations to make sure that they understand it, and I know that they do appreciate what is needed. We have been providing training, and well, in fact, officers do welcome our training sessions. They do find it helpful, and they have given us the feedback. And in the future, we'll try to see how we can further enhance the training programs. Fine. Any other questions from other members? If not, then that's it for this item. Next, we will go to the fourth item on the agenda, updates on the civil service pay level survey. First of all, for members who would like to speak, please press your request to speak button. Again, would like to invite the Secretary for Civil Service, Mrs. Ingrid Yang, to brief us on the paper. Paper CB bracket 4215/2024 bracket 04. Well, the Standing Commission on Civil Service Salaries and Conditions of Service submitted its report on the 2019 Civil Service Pay Level Survey, having completed Stage 1 and make recommendations to the government whether to proceed with stage 2. We now briefed you on the report as well as our position. Well, the government's civil service pay policy is to offer sufficient remuneration to attract, retain, and motivate staff of suitable caliber, to provide the public with an effective and efficient service, and to ensure that civil service remuneration is regarded as fair by both civil servants and the public that they serve, through maintaining broad comparability between civil service and private sector pay. In 2007, we introduced the improved civil service pay adjustment mechanism. We also we have the annual pay trend survey to ascertain year-on-year pay adjustments in the private sector, and the 6 yearly PLS to ascertain whether our pay is broadly comparable with the private sector pay. In 2014, the 2013 PLS was completed. In 2019, the government invited the Standing Commission to conduct a new round of PLS. Having considered the impact of the COVID-19 pandemic on the local society and global circumstances, the Standing Commission decided that there should be a two-stage approach. Stage 1 is preparatory in nature, like reviewing and formulating the methodology and the scope of the survey, complying a list of civil service benchmark jobs, carrying out the job inspection process, etc. And then we also consult the staff to ascertain the major functions and responsibilities of the benchmark jobs. For stage 2, we'll collect the data and we'll also have an analysis and we'll match the civil service benchmark jobs with the broadly comparable jobs in the private sector, and then the Standing Commission will then submit its recommendations. Under the two-stage approach, the Standing Commission would, upon completion of stage 1, recommend the government on whether and when to proceed with stage 2 of the PLS, having considered all relevant factors, including the then state of labor market and overall economy. The consultant engaged by the Standing Commission completed the work end of 2023. In February 2024, the report was submitted to the government. Well, the Standing Commission has noticed that the labor market has dwindled, and then we have a prominent surge in vacancies in the private sector. In other words, the labor market has undergone severe and unprecedented turbulences, impacting on the pay practices and levels in the market. It is believed that under the circumstances, that is, regarding the huge uncertainties, if we are to collect pay data in the private sector, and even when we apply the criteria, apply the data, it will be inappropriate, untimely, jeopardizing the credibility of the survey, and it will go against the policy objective of having a PLS. Therefore, the Standing Commission considers that we should not be conducting the second stage of the current PLS. To make sure that it is a reliable and credible survey, we believe that the Standing Commission is of the view that we should wait for the circumstances to stabilize so that we will not be affected by transient factors. The Standing Commission has also suggested that before the government decides on whether to have another round of the PLS, we should look at the labor market conditions. The Standing Commission has also noticed that the government has a number of talent trawling measures introduced recently, and they are for 2 years, most of all. So we should revisit the conditions in a reasonable period of time for the conduct of a PLS. We've invited staff views whether there should be a stage 2 PLS would also affect the disciplinary services as well as the directorate officers. Therefore, we have invited the Standing Committee on Disciplinary Services, Salaries and Conditions of Service, and the Standing Committee on Directorate Salaries and Conditions of Service to offer the views. The Sitting Council will take into a full account of the recommendations of the Standing Commission, the views from the stakeholders, before taking a decision on the way forward of the PLS. We are happy to invite your views and consider your views and take your questions.
Thank
Thank you. I can see that 5 members who pressed the request to speak button. I'll read out the order. Dr. So Chang Wing, Dr. Ammon Yu, Mr. Kwok Wai Kerr, Mr. Stephen Ho, and Mr. Lai Tong Kwok. Thank you. Dr. So Chang Wing. I do understand where the administration is coming from, and I do support the relevant recommendations. I do have some questions. It is said that stage 2 will not be conducted. When would be an appropriate timing to conduct stage 2? Is it the case that you will perhaps commence stage 2 in 2 years, because it is said that it is considered that perhaps in 2 years the job market would stabilize? I believe the work in stage 1 has been completed. If stage 2 is undertaken several years later, will there be any problem with the interfacing? Thank you. Secretary. Thank you. Well, as I said, the Standing Commission noted that we have a labor shortage across various ranks, and that some talent trolling measures have been introduced, and these measures would be effective for 2 years tentatively. It is thus suggested by the Standing Commission that the condition should be revisited after 2 years, because by then we will know whether the talents admitted could address the manpower shortage problem and whether they are of the right sectors that would address the manpower shortage problem. So this time frame was raised with reference to the period of implementation of the labor trolling measures. It is not necessarily related to whether the job market would stabilize. As for whether we will commence stage 2 right away with our results obtained in the stage 1 work that we did, or should we undertake stage 1 work again, it would depend on the circumstances then, because in stage 1 we did find out information about private sector jobs to see whether they are broadly comparable with civil service jobs. But even civil service jobs would have changes. For example, with the adoption of technology, some low-level positions are no longer necessary. And if we continue to compare such positions to positions in the private sector, which may have undergone such changes as well, but probably at different paces. So it would really depend on the circumstances. For example, how much time has passed and what changes there are. So we will see then whether we'll need to undertake the work in stage 1 again. Well, I want to say that for the top talent pass and certain talent admission schemes, they do not require talents to have a work contract in place before they come to Hong Kong. That is, they can look for work after they have come to Hong Kong. Well, how will you take this into consideration when you consider the data collected? Thank you. Secretary. Well, regarding the manpower shortage problem, we have government departments that would review the situation every now and then. And for those admitted under the Top Talent Pass scheme, they may not require a contract to come to Hong Kong, but then when their visas expire, whether their visas would be renewed would take into consideration whether they have work here. And I understand that some departments would investigate how many of those admitted under the scheme have already come to Hong Kong. So from different data collected by different departments, we will be able to tell whether the manpower shortage problem is alleviated by the talent trolling measures. Thank you. Dr. Amin Yu. Thank you. I understand that if we go straight into stage 2 a few years later, we may have some issues statistically, as in we will not have updated data. I do have my concerns with the current approach adopted by the administration. Will the administration consider the pay trend survey and the pay level survey can be consolidated? For example, every quarter the Census and Statistics Department would conduct a survey, and one of the considerations would be pay of the households. Would that help the civil service compile a pay trend survey? And we also have the LWB that would conduct a territory-wide manpower survey. So do we really need to conduct a pay level survey on top of that? Because I think we are just trying to monitor trends here, and we do not need the trends to be specific to the civil service and certain private sector jobs. Wouldn't a territory-wide survey be enough? Thank you. Secretary. Thank you, Chair. Indeed, the LWB and other departments would have surveys on pay of different sectors, especially the private sector. But for the pay trend survey or the pay level survey, they are more defined in scope, and they are more detailed. For certain civil service jobs, they may not have comparable jobs in the private sector. And for certain positions in public bodies, their pay would be determined or linked to the pay of civil servants, such as teachers in public schools, and there are quite a number of them. So often these surveys may be affected by the overabundance of employees in public bodies. I think there is the need to look at comparable private sector jobs conditions as a result through the pay level survey and the pay trend survey. Excuse me, Chair. The pay trend survey would look at year-on-year adjustments, and companies in certain sectors will be identified in the pay trend survey. We would also implement a ratio for larger and smaller companies to be considered in the pay trend survey. So I think with such requirements implemented, the survey would be more comprehensive and targeted. And these considerations may not be necessarily taken into account in other surveys done by other departments or bureaus. With the work situation or economic situation of the overall labor market or economy, these are factors that we would take into account as well. So we would definitely draw reference to surveys conducted by other bureaus and departments as well. Thank you. Chair, I do have a follow-up. I want to ask how much is spent on the conducting of pay trend surveys and pay level surveys. Well, for the pay trend survey, from what I understand, for stage 1, it cost $3.8 million, and for stage 2, because we do not plan on commencing stage 2, we do not have the relevant figures. As for pay trend surveys, we would not need to engage outside consultants. We have a commission. We also have a secretariat that would consist of civil servants, and they do not have that many officers working there. They would only have to issue questionnaires to the relevant companies, and after the companies have completed questionnaires, they will handle the relevant completed questionnaires. There is no additional cost involved. Thank you. Mr. Kwok Wai Kang. Thank you. I will ask questions again with my not so ideal voice. As said by other colleagues, the 2023 pay level survey was done at this point in time because the 2019 pay level survey could not be done due to the black-clad violence. And it is deemed that there is serious turbulence in the labor market. That's why it is recommended that stage 2 should not be undertaken. I do understand that there may be serious turbulence, but this is a subjective conclusion. I don't think they can say specifically what turbulence there is. So I want to ask, is it the case that they are still complying with the 6-yearly mechanism of the pay level survey? Because it is said that for this occasion, stage 2 would not be undertaken due to serious turbulence in the job market or overall economy. I think the administration should have justifications for not conducting a pay level survey, because if you are constantly changing, we may no longer conduct a pay level survey in every 6 years. I'm not saying the judgment made by the Standing Commission right now is incorrect about the serious turbulence, but if the circumstances are similar 2 years later, it will no longer be a turbulence. And it will be 2025 that we may commence another pay level survey. There would be a 12-year gap from then, between then and the previous pay level survey, and there may be a significant increase in the pay and benefits of civil servants. Does the government have the relevant resources to give out that required pay?
I come to my second question. If you don't have it in 2025, then the following one will take place in 2031. So a gap of over 20 years. So we'll be lagging far behind. members are worried about the relevance of the exercise, we have manpower shortage, and for anybody wishing to poach manpower, they will certainly set their eyes on the civil service. If we do nothing, then it means that there will be serious wastage, and you would jeopardize the stability of our civil service. Secretary, a few questions. Allow me time to address them thoroughly. First of all, the background. It's not because it was not carried out in 2019 because of the Black Clad riot. In 2022, early that year, we started to be impacted by the COVID-19 pandemic. Face-to-face contact was not possible, and the economy was hard hit, and nobody could tell at the time when the pandemic would come to an end. So as a result of that, many factors, the Standing Commission came to a certain view. Even though we could proceed with stage 1, for stage 2, it would require a lot of interaction and face-to-face interviews, and the economy has to be in a stable shape before we can tell it is a good time to do so. A lot of business modes have been transformed as a result of the pandemic, and therefore at that time there was a decision to have a two-stage approach. We decided to go ahead with stage 1 first. That's the background. So we're still talking about the 2019 PLS, and it is stage 1. It's taken more time because the pandemic lasted for 3 years. A lot of face-to-face interviews had to be postponed, and that's why it's taken that long to complete stage 1. Turbulences in the market are not something perceived subjectively. We have collected a lot of data. We have got many vacancies in the Hong Kong labor market. It is well known, it is a fact. It's reached such a state that the government has to introduce trawling exercises just to introduce labor and manpower. We have got the top talent pass scheme, we've got the quality migrant admission scheme, as well as the supplementary labor importation scheme. It shows that we have manpower shortages at different levels of the labor market. Well, the consultant, the Standing Commission, ourselves have observed that the private sector is more flexible. They can respond very swiftly in terms of pay levels, conditions of service, fringe benefits, etc. Such can go up or down very rapidly. So in the light of this, we can appreciate the Standing Commission's view that is, this is not the appropriate time to proceed with stage 2. It isn't just a matter of variations of the pay conditions and the service conditions. The government has also introduced many measures to stabilize the labor market. Well, in fact, it is a very detailed exercise. We have different ranks with different jobs to be covered. It takes time. By the time this is completed, and if the government's measures are effective and stability has been restored, then by that time, the pay levels will be subject to another round of adjustments, and so the pay data would be very different. If we are to apply the findings of the survey to the civil servants, it would be inappropriate and untimely, and that's why the Standing Commission has got this recommendation based on such a consideration. As to what should happen at the end of the day, we are happy to gauge the views of the LegCo members, but just now I'm sort of providing some background information for you, and indeed it is not a subjective view. For the Standing Commission's view, well, in fact, when I gave a reply to Dr. So's question, the Standing Commission is that we have to check whether the measures are effective or not. So it doesn't actually mean that even if we are to miss 2025, and despite short-term fluctuations, we can still reconsider or revisit the topic. It doesn't mean that we can only have 6 yearly cycles. There was a question as to whether there is a need to introduce drastic changes next time. Well, even if we have it once every 6 years, this is still likely. In addition, we are following the mechanism when we do have annual pay trend surveys. And for individual grades, if they encounter difficulties in recruiting and retaining staff, then we can carry out grade structural reviews. So we do have mechanisms to make sure that we can attract and retain talents to join the civil service so that we won't have serious problems. So we don't just count on the pay level survey alone. I hope I have covered all the questions, but we're happy to listen to members before we take the next step. Mr. Kwok. Thank you, Chair. Thank you, Secretary, for your reply. Well, in fact, civil servants have told us that they are really worried, and I hope the Bureau can appreciate that. For the pay level survey exercise, please elaborate more on the operation so that we can understand it better. For the annual PTS, as to whether they can address their concerns, well, not necessarily. Many civil servants have told us that the government will have the final say in the light of the pay trend survey findings. From time to time, they have views different from the government's decision in relation to the adjustments. So please make sure that you talk to them, listen to them, just to make sure that the mechanism can safeguard the interests of the civil servants, and then there will be stability and sustainability. Secretary, surely we will enhance our consultation. In a few days' time, we'll be meeting with the civil service unions, and we'll listen to their views, and they will tell us what they want in relation to the way forward, and we'll be happy to explain whatever issues they're interested in. Mr. Lai Tong Kwok, regarding this consultation paper, I think we are caught in a dilemma. Well, the established mechanism is to have it once every 6 years. As a result of the pandemic, it has been delayed. Now, if we are to complete the unfinished job, it will mean that there is a time gap of over a decade. So irrespective of the way forward, I'm afraid there is a huge difference. The Standing Commission has given us justification for its finding, for its decision. I think the Standing Commission has been very sort of pragmatic and practical. I've been talking to some civil service associations. Of course, their views are divided. Some are in favor, some are not. Some are of the view that we should still go ahead with stage 2 of the PLS. I would say that I support the Standing Commission's recommendation. But the outstanding question is, we still have to deal with this matter. Well, for the civil servants, their position is such that, of course, the pay level would be of great significance. But in addition to the pay levels, what about the fringe benefits? Can you not do something about it? I do understand that the government has a very tight budget, and we can't really expect a lot of good news from the FS in 2 days' time. Yes, indeed, there is a deficit, but still, we should make good use of the resources already set aside so that we can enhance the flexibility of the fringe benefits that civil servants are entitled to, so as to enhance the sense of belongingness. Well, the Secretary talked about the private sector. When it is found that they have difficulties in recruiting and retaining staff members, the private sector would increase the pay. They would also provide better fringe benefits. To me, I think the government should follow suit. We should do the same. I think we should have greater empathy. We should be more flexible. Say, for example, for our dental service, you have got money left, so you are going to outsource the service. To the civil servants, they appreciate that the government is being sincere and the government is trying to help them. Well, of course, we have got a meeting on the we have got a subcommittee on the benefits of the civil servants. Other than recruitment, we also have retention difficulties. Now, it doesn't hurt for a civil servant to hand in a resignation letter after serving 10 years. Quite different from the past. In the past, a officer with a 10-year service record will lose all the pensions if they resign after serving 10 years. So I just want to know if you would introduce measures to enhance the mechanism so that people would be convinced that the government is sincere and effective in providing better working conditions and better service conditions for them. Well, you don't always have to go to the FS to get money to do it. You can work within your parameters. Why not be more flexible? Tomorrow, we have got a discussion paper that is for officers on the new terms of service for the MPF that they have received. Of course, as of now, they are not able to withdraw it. But can you be more flexible? Must you adhere to the books, the rules of the books? I think we can be more frank and we should exchange our views with an open mind. So we can put our minds together, and I'm sure collectively we can think outside of the box and we can find new ways to address the problems. So I do hope that the Secretary will try to do more for our civil servants so that we all put our potentials to the full sort of use, so that civil servants won't just be collecting their pay by being sort of just delivering what is expected of them. I hope that everyone will do an extra mile, and then the efficiency of the public service will be greatly enhanced. I do hope that we will consider my view.
Secretary, thank you. Chair, and thank you, member, for your suggestions. In the past 1 or 2 years, we have proposed many enhancements to benefits provided by civil servants and other staff members. We have, for example, proposed enhancements to the leave mechanism for those who would take more than 5 days of leave. If the last day is a Saturday, the half day will not be deducted. We have also implemented some friendly measures. We have proposed and will soon implement the wedding leave arrangements, for example. Regarding medical benefits, we have the pilot scheme on dental scaling. And these are all enhancements that we made with existing resources. We will continue to explore whether there is room for further enhancement of our benefits. We will definitely do more if we can. And we have also offered to officers on new terms education allowance for their children studying on the mainland. Again, as I said, many of the enhancements do not require additional resources, and in fact, there is something indeed that we cannot compare to the private sector, such as the fact that the private sector would offer club membership to their senior employees. But I would say that employees, civil servants, work in the government because they are dedicated. And as you may know, we will soon revise the civil service code. We do want civil servants who are dedicated. They should not treat their work as ordinary work in the private sector. Civil servants have the duty to implement policy objectives of the government. It's not that we are too prudent with our benefits or pay. We have tried our best to provide better working conditions for civil servants so that they can use their potential to the fullest in their positions. I would like to clarify again that dedicated civil servants will no longer be dragged down by the black sheep in the civil service by enhancing the civil service disciplinary mechanism discussed in the last agenda item. Thank you. Chair, I do have a follow-up. Will I be able to follow up on that? Thank you. Yes, you can. Thank you, Chair. It is said that for civil servants, one of their concerns is that they would have to take at least half a day to deal with personal matters, but often they would only need 1 to 2 hours to deal with their personal matters, such as to meet with teachers of their children. Was it possible for you to let them to leave for just 1 hour? Of course, they shouldn't be late. If they were out for 2 hours, we should deduct the overtime that they have for 2 hours. I think, as I said, we can be more flexible when providing benefits, and when you are communicating with the staff side, you should listen carefully to their views. I understand that things that would require additional funding may not be possible, but I think you can definitely do more to boost morale of civil servants. Thank you, Secretary. Thank you, Chair. We will definitely explore different ways, and we will maintain close liaison with the staff side. Thank you. Next, it would be Ms. Nixie Lam. All right, thank you, Chair. I think we should focus our discussions on the pay level survey. Colleagues have raised different suggestions, and as I understand, the survey is done because we want to maintain broad compatibility between civil service and private sector pay. I am elected as an election committee member. I have often heard people say that the government would pay double or triple to headhunt professionals in the private sector, and that has caused in turn higher works fees because this is especially prevalent in the engineering sector. And I think we can really draw reference from what Dr. An said. He said we should refer to indicators of market prices. And as I said, professionals in various professional sectors have raised this issue that you have paid double or triple to do the same work in the private sector. In fact, it was not just one professional that told me this. It was in the 60s. Like, there are 68 people that have told me this. So will you review the situation and the pay paid to certain officials? Thank you. Well, Secretary, please. Thank you. I think bureaus and departments always have the responsibility to monitor their establishment, and there has been a zero increase in establishment since a decade ago. And whenever there is an increase in the establishment, there would be prudent consideration with regard to the proposed increase. So there is a decrease in positions due to wastage, but then there are also new positions that are created based on new requirements of the bureaus and departments. But when these positions are added, the relevant bureaus and departments would carefully consider the justifications, and audits would be conducted to see if technologies can be adopted instead. And in turn, with the consideration of whether technologies can be adopted, manpower may be reduced. As for whether bureaus and departments have paid double or triple to attract professionals in the private sector to join the government, as I understand, pay is formulated with reference to qualification requirements of positions. There are only 1 or 2 grades that would offer 1 or 2 additional pay points. For other grades, they would adopt a same entry point. So I believe there won't be a huge gap between the civil service and the private sector, because as I understand, the private sector would be very prudent when hiring university graduate positions. I believe there won't be that much of a gap, but I do understand that for certain positions that would require those candidates to have a master's degree, so they may offer higher pay. As I said, most grades would offer similar entry points, so I don't think what you said would happen. Well, I would like to clarify that these scenarios are very much real. I can tell you more about those after the meeting. Well, Secretary, I believe we would require for most positions that we would have civil servants promoted gradually to higher level positions. For certain positions that would require candidates to have a requisite number of years of experience, we may offer higher pay points with reference to the years of experience that they have. Otherwise, we would offer the pay points based on the entry points of the grades. If necessary, the bureaus or departments would review the situation. We can definitely pass on your views, but as I understand, there will not be much of a gap. Let me add something. Well, it was when I first became a electrical member that professionals told me of this, and I talked to certain smaller and medium-sized engineering companies, and there was one case that a high engineering employee who was doing relatively well, he or she was earning a 25,000 income at the company, but the government offered them $80,000 in pay. So there was no way for them not to go to the government instead. So I would often hear such complaints from the private sector. I am thus taking this opportunity to let the government know that this did happen. And after the meeting, perhaps I can communicate more with the administration on this, because this would lead to unhealthy competition for employees, and that would in turn increase engineers' fees or engineering fees. Well, if we are offering $80,000 to a certain individual, it would most definitely not be an entry-level position. And in fact, for government dentists and certain police force officers, they would not get a pay that high. I believe it was because the individual met the relevant requirements. They may be a contract employee, or they may not even be a civil servant in the first place, that they are just participating in a public project. And they are in fact engaged by a consultant company, and as I understand, $80,000 would most definitely not be an entry-level pay.
I know that the police may also employ someone at the rank of police superintendent, not for police duties, but for something like communications. It's a case of a contract staff, and so maybe Ms. Lam can provide more information to the Bureau for consideration. Now it's my turn for my own questions. Regarding the CSB's suggestion to take on board the recommendation of the Standing Commission, namely not to go ahead with stage 2 of the pay level survey, I can fully appreciate the prevailing circumstances. But then for civil servants, whether we are talking about the 4 central consultative councils, namely Senior Civil Service Council, Model Scale 1 Staff Consultative Council, Police Force Council, the Disciplinary Services Consultative Council, or the 4 major service-wide staff unions, you do take their views seriously. And according to the paper, 4 rounds of meetings have been held. That's the case for the central consultative councils. But then for the service-wide staff unions, you have only been liaising with them in writing. I'm talking about the Government Employees Association, Hong Kong Civil Servants General Union, Hong Kong Federation of Civil Service Unions, and the Government Disciplinary Services General Union. I know that different unions and different council members are affected. So please don't be satisfied with written communication with the service-wide staff unions. Perhaps you should find time to meet with them in person. Secretary, please meet with them so that at meetings they can fully appreciate the consideration of the government and you can get more views from them so that they can sort of assist you in sort of making them understand what is at work. Well, the last one was conducted in 2013. The findings may result in a pay rise for some, or there may be a pay decrease as a result of the corresponding circumstances in the private sector. So some civil servants are really worried. So it is important to give significance to communication and dialogues. Well, since pay rise or pay cut may be involved, so it will have an impact on the staff morale. And what about 5-day working week? I understand that a small number of departments are not able to fully implement the 5-day working week. So you need to make sure that there is consistency, there is equality in terms of their leave entitlements, for example. Well, that policy has been in place for a long time. Some departments are able to implement them, but others may not. And then if there is a likelihood of pay rise or pay cut or other erosion of benefits, they may not support it. So I just wonder if you can have further enhancements so that other than the pay levels, they will be given assistance in other ways. So I hope the government will consider further measures so that previously decided objectives can be reached. Well, in accordance with the mechanism, one was carried out in 2013, so it seems that the next one would only come up in 2025, and then the next one may only take place in 18 years' time, and that would mean major fluctuations in the pay levels. It is not right. We should be more timely. Secretary, would you like to take my 3 questions first? Thank you, Chair. Well, as of now, communication with the staff side, it comes from the Standing Commission. They have been meeting with the 4 central consultative councils in person, and then they have written communications with the 4 major service-wide staff unions. Currently, it is the CSB that is consulting the staff side. As I have indicated, in a few days' time, I will be sort of having meetings with the 4 central consultative councils and the 4 major service-wide staff unions. So I'll be listening to their worries in person, and I can sort of get views from them, and I can learn from them directly as to what they are worried about. And as I have said in my reply to Mr. Lighton Kwok's questions, in terms of fringe benefits or family-friendly policies or ways to enhance the working conditions of civil servants, streamlining the procedures, etc., all such would also be covered by our efforts to enhance them. We all want officers to be able to to realize their full potentials so that they won't have their morale being affected. So we'll certainly work on such areas. Chair, but of course we have to realize that there are restrictions or limitations and it takes time, and then there may be a need to change the job types. Currently, the labor market is suffering from huge turbulences. We are not sure whether the government's measures to draw talents and attract labor will be effective in stabilizing the market. So in due course, that is given that we take on board the Standing Commission's recommendation, take a further view. Otherwise, we have to be rigid, and then I don't think we'll be that rigid and say that it will be 18 years later that we have another one. Well, once the transient turbulences are gone, the Standing Commission will probably recommend another pay level survey. The mechanism is still there. We are obliged to carry it out. Well, we do have certain temporary measures, and they will be subject to review in the following 2 years. This I appreciate. But what about the grade structures? I think you should take the opportunity to reconsider it. Some posts are no longer relevant. This has been so for 10, 20 years, and then the academic qualifications needed will be different. And as a result, you have recruitment difficulties. Why don't you take this opportunity to address them? If there is indeed a need to carry out grade structural reviews, please go ahead quickly. And then it means that once we have another pay level survey, we can find relevant data from the private sector. And then for those posts that suffer from long-term difficulties of recruitment and retention, you should take this measure as well. We'll do so, Chair. Any other questions from other members? If not, then that's the end of this item. Item 5, AOB. Anything under AOB? If not, then that's it for today's meeting. Thank you. Thank you.